I don't think I really need to say too much about our topic, but just to give you the full title of our panel, it's Standards and Synergies, Creating Legal and Operational Frameworks for Global Cooperation. We're largely regionally focused in this part of the world. We don't have the rest of the world too well represented, but we do have some minds who understand what's going on in the rest of the world, and perhaps that can feed into our discussion as well. But we know how important it is to protect critical infrastructure. That was impressed upon us by the presentations that we've had already today. We know that the task is becoming more urgent than ever. We've already seen that there have been numerous incidents, and there been descriptions of around 200 incidents of damage to critical underwater infrastructure, cables, pipelines every year, and that when we look at the Baltic area, that is particularly under threat, also because the volume, the amount of material that goes back and forth between the countries, the Baltic countries that border the Baltic Sea, is enormous. Also in the North Sea, tremendous amount of infrastructure that's exposed there and potentially under threat. But also we've been reminded of how unexploded ordnance under the water can be problematic in a number of ways. We've heard an example of how it has been exploited by terrorists for use in an attack. We've heard different ideas about how much risk is involved there. But we do know that if a dump, for example, were to be targeted or hit during an attempt to strike a pipeline or an underwater cable, that would amount to an environmental catastrophe as well, not to mention a threat to shipping and safety. So without further ado, I'm going to introduce our three panelists, starting with Dr. Moritz von Rochow, is a research and teaching assistant, here we go, at the Walter Schucking Institute for International Law right here in Kiel, at Kiel University. Take your seat. We have someone who's working very hard today. Stylianos Tzimis, you've heard his keynote this morning. I don't think he needs to be introduced. I misrepresented him as a commander earlier, but of course he is a captain, and we should acknowledge that. But he's not in uniform here, and he's serving in a very important function at the Center of Excellence, which he explained to us involves EU member states and NATO member states as well, and there's a lot of super interesting work going on there. Very valuable knowledge. Thank you. Also with us, Domas Petrulis is a policy officer from DG MARE at the European Commission, who's going to focus primarily on UXO, which there's a lot of UXO expertise in this room, so it's important that we get an idea about both. So I know that we do have some presentations here. Why don't we just get going with those? That we're going to follow the same pattern as before. I have a few questions based largely on what we've heard this morning so far. That's raised a lot of questions in my mind, and then we'll open the floor to you. So, Moritz von Rochow.
Thank you very much, and welcome. I'm really grateful to be here again after 4 years, I think. The last time I was sitting there where you sit now as a moderator. Now I am allowed to speak myself because I've been doing some important research on the protection of infrastructure and the legal solutions. And I've not just doing this research myself, but I included members of my institute, students who wrote a thesis about this, and they all came to similar conclusions. What do you read in the press? What do you read in the press? That we must remain inactive because we can't do anything for legal reasons is wrong. So I just put some press statements there on the slides. You see the rights of the coastal states are very limited. or Völkerrechtsblock saying there are serious security gaps in the current legal regime for the protection of submarine cables and affected states are still struggling for answers. And there are basically two different kinds of lawyers. Ones who say, oh, well, things aren't possible, it's legally risky. And then there are those coming from a lawyer's perspective, showing you how to make things possible. And I come from the latter perspective. So instead of looking, well, we looked at all the provisions like the 1884 Sea Cables Treaty, the SUA Convention on suppressing maritime terrorism, etc., and all the provisions. And pretty much it's right. You can't seize or board a ship without the consent of the flag state, which you know is pretty difficult if the flags change on a daily basis. So I was looking at pretty much the only provision in the law of the sea which gives you rights to seize and board ships without the consent of the flag state. And I was assessing if we can apply this rule to the present situation of sabotage acts and jamming, acts of jamming in the Baltic Sea under this provision. And this is, it might come for you as a surprise, a rule in Article 101 UNCLOS, a treaty ratified by the majority of states, dealing with piracy. And most of you will now be struck, well, piracy, if you have looked into the definition, needs two ships. So an act of violence or depredation committed from one ship against another ship. Well, that is partly true, and this is the way the prohibition of piracy has been applied in cases of Somalia, the Malacca Strait, but this is not the whole definition of piracy. If we look further into this provision, and for a strange reason, the definition stems from the High Seas Treaty from 1958, has been drafted by the Harvard Draft Research Commission in 1932, and for a strange reason, it pretty much didn't change when it was included in the UNCLOS Treaty in 1982, coming into force into 1994, so it's a valid law of rule of international law. It says that piracy consists of any of the following acts: any illegal act of violence or detention or any act of depredation committed for private ends by the crew or passengers of a private ship. That's what we're dealing with if we're dealing with a shadow fleet, so private ships, formerly private ships at least. And we used to apply the literal little with a small I on the high seas against another ship or aircraft. That's what we do in Somalia or the Strait of Malacca. But there is a second subparagraph, and it says, against a ship, aircraft, persons, or property in a place outside the jurisdiction of any state. And now my question to you, cables, pipeline, any other infrastructure on the high seas or in the exclusive economic zones, this is property outside the jurisdiction of any state. So this rule is applicable. The second paragraph is about the support, voluntary participation or inciting. This is of no relevance for us at the moment. So what can we do if we refer to piracy? According to Article 105 UNCLOS, on the high seas or in any other place outside the jurisdiction of any state, every state may seize a pirate ship or a ship or aircraft taken by piracy and under the control of pirates, and arrest the persons and seize the property on board. The court of the state which carried out the seizure may decide upon the penalties to be imposed and may also determine the action to be taken with regard to the ship's aircraft or property subject to the rights of third parties acting in good faith. So if we declare, and this is legally possible, those acts as acts of piracy, then states have nearly no limits than dealing with these ships in the exclusive economic zone or on the high seas. It's maybe sound a bit tricky to call these people piracy, but the provision works, and well, that's what law is for, to deal with these situations. There might be coming up a question if this provision actually has been drafted to protect submarine cables. Well, in fact, it hasn't been drafted, or maybe it has, we don't know for sure. Well, the state parties drafted the 1884 Convention on the Protection of Submarine Cables. There were also the idea to just declare these people pirates. And then this convention didn't get promoted much because state parties said, well, it's better to have some kind of constitution of the sea, and they drafted the High Seas Convention in 1858, and the Treaty on the Protection of Submarine Cables of 1884 vanished somewhere in oblivion. So they didn't use this ancient provision anymore. And is this provision has really been drafted to include acts against things which are not ships? Well, the International Law Commission in 1956 is pretty clear on that. They drafted this provision to protect property on beaches which were at that time terra nullius, so having not been occupied by states. And well, a beach is not the ship, isn't it? So, as this provision pretty much has been drafted for this kind of acts, then we need to ask ourselves, does this acts of sabotage, are they made for private ends? What are private ends? We clearly don't need this animus furandi, this will to steal, so we can discuss if maybe there is private ends behind us, but well, let's assume those captains and crews of the Shadow Fleet, they don't just act for themselves. Pretty much sure they gain something from it. So they are to be treated differently than, for example, Greenpeace activists who seize oil platforms or other ships. So I see the private ends valid here. So if we deal with them as pirates, let's look how it works and if it works. I have the graph how the piracy diminished in the Strait of Malacca, where we have the regional cooperation agreement on the combat against piracy. And you see, well, there's still piracy going on, but piracy diminished due to the cooperation of states to deal with piracy and armed robbery against ships. And the same is true for Africa and the Horn of Africa. I have been myself a liaison officer in the Horn of Africa in 2009, so I've been active in the combat against piracy back then, and we succeeded in diminishing piracy, and especially those states, or the littoral states, they succeeded by international cooperation to get rid, or pretty much get rid, of piracy. How did they do it? They agreed on the Djibouti Code of Conduct and the Regional Cooperation Agreement against on piracy in Asia, where they ruled on things like the question of pursuit and jurisdiction of a ship. So if an act of piracy happens beyond national jurisdiction, may I pursue this ship to the national jurisdiction, to the territorial waters of another state? They agreed on this. They said, well, if it happens within national waters, it's not piracy, but we need something similar. They called it armed robbery against ships or armed robbery at sea. I think dealing with submarine infrastructure, armed robbery at sea would be the better term. They agreed on having embarked officers. So if you have a ship from Somalia or a ship from Djibouti, they will have embarked officers from Kenya or Tanzania on board. If they seize the pirates, then they have the responsible authority on board to deal with these pirates. They introduced national focal points. Every state has a focal point which you can address, saying, well, I've been attacked by pirates, and who divert the information. They created information sharing centers to centralize and gather the information and to coordinate these efforts. They have an incident reporting system. They rely on mutual assistance. When one state gets attacked or suffers from piracy activities, another state may deal with it, and they engage in common training missions and education missions to train the officers dealing with this. So, is it just my personal perspective that we can use the law on piracy against this? Well, I wouldn't stand here that bold if I wouldn't have the support of the International Law Association, the most prominent body assessing international law. They say, while this interpretation, they refer to the interpretation as piracy, is legally plausible, so they admit that it is legally plausible, it is uncertain whether states will accept that they have the right vis-à-vis intentional damage to submarine cables and pipeline under law of the sea, Articles 101 and 105. So it is not a question of the law, it's a question of will of the states and the authorities to deal with it. Because International Law Association clearly says it's plausible to declare these acts as acts of piracy. I didn't talk too much about the question of jamming. We have another different question there. Is jamming of GPS sensors, is this a violent attack within the definition of piracy? Maybe we can elaborate on this question later. It's a bit more disputed. I found an assessment from the Gdynia Maritime University. I've been in Gdańsk, in Gdynia last week, and they dealt with piracy, with jamming acts in the Baltic Sea, and they found out that most of those acts, they don't stem from land-based sources, but are planted on ships, presumably ships of the Shadow Fleet. So we have private ships jamming GPS systems and other global positioning systems, which also might come under the definition of piracy if we agree that the jamming is an act of violence against a ship, and they suggest that jammers are likely installed on vessels and that we need a high-density monitoring network which would enable continuous tracking of these sources. So we need some more research in this sense, and a dedicated monitoring system would provide an early warning mechanism allowing operators to respond promptly to interference events and minimize potential disruptions. If you're interested in my sources, I put them here. There are plenty more. I just gave you the most important ones. If you want to contact me further on my elaborations and the studies which have been carried out at our institute, there's a very interesting and master thesis on this topic too. Here are my contact details, and you are free to contact me with any further questions which maybe come up when you are on your way back home and thinking about piracy. Let me just have one little remark. As I'm a scholar of international law, I got asked frequently, what is the point in international law? Who does care for it anymore? I mean, we see the violation of international law all around the world, all around the place. Well, international law isn't just endangered by rogue states who just disrespect it, but also by states who take international law as an excuse for remaining inactive. Just remember the beginning of the Ukraine war, where we thought we can't support Ukraine with more than 5,000 helmets for the sake of international law. So international law has its limit, but we should use these limits to become active, because remaining inactive threatens, according to my point of view, international law as much as disrespecting it would do. Thank you very much.
Thank you, Moritz, for that illuminating, your illuminating presentation there. I think for many in this room who have heard exactly the kinds of, read the reports that you referred to at the very beginning of your talk, this helps us to expand our ability to even think about international law and with the tools, legal tools that are there that may allow us to achieve greater enforcement to bring about a better state of affairs. Anyway, for respect of time, again, we're going to move on very quickly because Stylianos Tzimis has to leave us promptly at 1:30, and that's we completely respect that. Do you have a presentation for this section too? Absolutely, marvelous, good. Okay, go ahead. I know that what we just heard from Moritz, by the way, picked up on some things you touched on earlier. I think this could make for a really interesting discussion. Go ahead.
Thank you, Terry. So here I am again. Sorry for that. The task of monitoring hybrid incidents targeting subsea cables and pipelines is both highly relevant and impactful. However, the task of identifying potential legal paths in international law for protecting those valuable assets is extremely complex and in many cases highly challenging. The good news is that the current international legal framework provides states with concrete and clear mechanisms to protect their subsea infrastructure within their territorial waters. The bad news is that the subsea cables and pipelines extend beyond territorial waters. And that is the point. The expansion of critical undersea infrastructure outside states' sovereignty makes their protection a matter of national and international concern. Outside territorial waters, the current legal framework appears to challenge the ability of states to safeguard critical cables and pipelines. In areas with limited or no sovereign control, such as the high seas or exclusive economic zones, the state authority is complex. It becomes particularly problematic when swift action is required to prevent or respond to hybrid acts of sabotage. Since the 2022 sabotage of the Nord Stream pipelines, critical undersea infrastructure has increasingly become a target, and notably, all the incidents have occurred outside territorial waters. This is not a coincidence. All of these cases clearly fall within the realm of hybrid attacks and are extremely difficult to attribute. And while these attacks have had profound security and economic impacts on the affected states, in legal terms, they fall short of constituting a direct armed attack on state sovereignty. Such an incident occurred on Christmas Day 2024 in the Gulf of Finland, when the English allegedly damaged the Estlink 2 power cable and 4 telecom cable, as we have discussed in my keynote speech. When such an incident occurs, a key question arises. Do the affected states have legal options to stop a ship from severing their cables and pipelines outside their territorial waters? The answer depends on the legal classification of the incident, something that would be interesting to examine in the next slides. Legal option number 1. Affected states may consider using armed force to stop such a vessel, either with UN Security Council authorization or under Article 51 of the UN Charter, which permits self-defense. While the Security Council can authorize armed force in response to serious threat, this route is often impractical due to the veto power of the Permanent Five, which can lead to political deadlock, especially in urgent cases like sabotage of undersea infrastructure. However, since the vessel was not a state warship nor part of a large-scale military operation, the incident likely does not meet the threshold of a use of force of armed act. Therefore, it may not justify the use of armed force in response. Legal option number 2. Affected states may invoke Article 25 of FARCIVA to stop the ship, but only if the strict conditions of necessity are met. Although such actions outside territorial waters typically violate the freedom of navigation, it may be justified if it is the only way for the state to safeguard an essential interest against a grave and imminent peril, and B, it does not seriously impair an essential interest of another state. Submarine cables and pipelines established through international agreements qualify as essential interest. Furthermore, intentional damage by a non-military vessel may breach the principle of non-intervention in the internal or external affairs of states. Therefore, such an attack may be regarded as a grave and imminent peril, justifying urgent protective measures. Legal option number 3. Affected states may invoke Article X of the 1884 Paris Convention to stop the vessel using designated maritime capabilities. The conventions oblige its 36 signatories to criminalize intentional or negligent damage to submarine telegraph cables and to take prevent measures. It grants state jurisdiction beyond territorial waters and provides a legal basis for enforcement and compensation in case of damage. However, its scope is limited to telecom cable, not pipelines. Notably, the Convention remains open to accession. For example, the United States is party, but not to UNCLOS, while Finland is party to UNCLOS, but not to the 1884 Convention. Legal option number 4. Affected states may appeal to the flag state, which holds exclusive jurisdiction over its vessels and the authority to prosecute damage to submarine infrastructure. This means that under a clause, affected states cannot stop a foreign flagged vessel outside their territorial water for such acts. While this rule is often seen as weak, it reflects the legal complexity surrounding submarine cables and pipelines, much of which extend beyond national jurisdictions and owned by multinational consortia. This makes jurisdictional attribution extremely difficult. Therefore, the only way for the affected state is to request the flag state to investigate it and take appropriate action. If the flag states fail to do so, it cannot be compelled due to the principle of sovereign equality. However, such inaction may trigger state responsibility under the ARCIVA for failing to prevent or address an international wrongful act. Legal option number 5. The previous speaker elaborated on this, but let's discuss a bit further on this. In principle, affected states cannot invoke Article of UNCLOS on piracy to justify stopping a vessel for damaging submarine infrastructure. This is because, under UNCLOS, such acts do not meet the criteria for piracy, which is defined as act of violence against ships or cargo committed beyond any state's jurisdiction for private ends by the crew of a private ship. However, some legal scholars argue that if the affected states have credible evidence that a crew was paid to intentionally damage undersea infrastructure, this could potentially meet the piracy criteria. In such cases, UNCLOS permits any state to seize the vessel, arrest those involved, and confiscate property beyond territorial waters. Legal option number 6. Affected states may invoke Article of UNCLOS on the right of visit if there are reasonable grounds to believe a vessel is flying a false or no flag. In such cases, a government a government vessel, may board, inspect, and, if necessary, detain and escort the ship to port for investigation. However, if the suspicion proves unfounded, the vessel must be released immediately, and the inspecting state may be liable for any resulting damages. Legal option number 7. Affected states may provoke the protective principle to stop a vessel if its actions pose a direct threat to national security, sovereign interest, or critical infrastructure. This principle provides a legal basis for asserting criminal jurisdiction over individuals responsible for such acts, especially when other legal frameworks fall short. And the last option, affected EU states may invoke the EU directive on maritime insurance and liability reporting to stop a vessel if there are reasonable grounds to believe that it lacks proper documentation or insurance and poses environmental or safety risks. The directive requires all vessels, regardless of flag, entering EU reporting zones, even in transit, to submit proof of insurance. Failure to comply may result in law enforcement actions by member states. This empowers the EU member states to take preventive measures against the so-called shadow fleet and its potential threat to critical undersea infrastructure. In summary, two major legal limitations hinder effective prevention and response to the sabotage of subsea cables and pipelines beyond territorial waters. The first one is that hybrid sabotage acts do not meet the threshold of a use of force or armed attack, limiting states' ability to respond militarily. The second one is that exclusive flag state jurisdiction over vessel beyond territorial waters means enforcement depends on the flag state's willingness to act, rather than on the coastal state most affected. In any case, to address these challenges, several legal pathways can be identified through the interpretation of international law. However, their effectiveness ultimately depends on political will, robust enforcement, and international cooperation. Thank you.
Thank you so much, Stylianos. You really are working hard today. I must admit, I think you're allowed to leave early, given all that you've done for us today so far. We only have 15 minutes left. I know you have to leave at 2:30, at 1:30 rather, and so if it's okay with you, Domas, I'm just going to postpone your presentation a little bit so that we can have a little bit of interaction with Stylianos before he has to leave us, because there's already a lot on the table, but you know we definitely will be certainly look forward to your presentation in a moment. That'll come up in I think 15 minutes. We'll just postpone that a little bit so we can have some discussion, particularly on what we've seen so far. And what we've seen so far gives us several suggestions about legal means for addressing the threats to critical infrastructure wherever it may be. Again, we're in this particular part of the world where the representation at this conference is primarily here in Northern Europe, representing, but we also have interest from outside. But we've seen examples from all over the world, including Asia and from Africa, of successful interventions to protect or to stop piracy. Now, piracy of a different kind, it must be said, but the kinds of incidents that we're talking about here with underwater infrastructure are being witnessed around the world. It's not just in this part of the world, but we're talking about our vulnerabilities here. So before you leave us, I would be very interested in hearing from you, Moritz, first of all, what you make of what Stylianos offered in terms of his suggestions that expand a bit on what you were putting on the table in addressing the threats to critical infrastructure. What do you make of all of that?
Well, I'm really grateful for your comment, and because it makes me doing a very deep dive. And I did this deep dive in my research because I was also struggling with these private end requirements. So you basically said, well, it can't be piracy because for piracy we need private ends. And it's doubtful if these Russian shadow fleets act on private ends. So we have to interpret why does it stand in UNCLOS that we need private ends? Where does this come from? And so I went back to 1982, to the UNCLOS Convention. I went back to 1958, to where we have the identical provision in the High Seas Convention of the Geneva Convention on the High Seas. I went back to the Harvard Draft Research Convention from 1932. And there is also what has already been those notions. So we need to go into the elaborations, the negotiations between the states. What did they mean by private ends? Why did they write it down there? And they did it for two reasons, basically. The first reason is to distinguish piracy from privateering, Kaperei in German, acts like Sir Francis Drake, who's been on a mission by the Queen to seize Spanish treasure ships. This was the idea of privateering. So pirates with state authority, and those pirates, they shouldn't be regarded as pirates, but they should be treated on a different path. That's why we have. That's one reason why we have this notion of private ends in there. So, in order to understand what is not piracy, we need to understand what is privateering. And I went to our library, which is the oldest library on international law in Germany, and I found a doctoral thesis from 1934 dealing with privateering. And it said, well, there can't be said much because everything is said in a thesis by Martens from 1795. And this book seems to be vanished. I found it. I found it in our library, so I looked it up, and it basically said that in earlier times, privateering fell under the law of war, and piracy didn't fall under the law. So privateering went with some privileges, which the pirate didn't have. And the privateer should prove these privileges by having a letter of marque, in German Kaperbrief. This is the ancient notion that you need, and the captain of the ship, or the state behind it, has the obligation to prove that this is a privateer and not a pirate. So, and if we say that the whole notion of piracy, the whole piracy definition comes from this tradition, it's up to the captain of a Shadow Fleet ship to prove that he's not a pirate, but a privateer. And I want to see the letter of marque of any of those captains, or I want to have the clear statement of Russia, no, this guy is not a pirate because he has our authority. But then we're on a different path, because then we talk about humanitarian law and the law of war. And I'm pretty sure that Russia won't admit that they are behind these acts, beside sending some Su-35 to rescue some of these Shadow Fleet ships. You have heard of the Jaguar incident. So it's up, the burden of proof lies with the ship, and that it's not private ends lies with the ship and with the captain. Let me just add, the second reason is to exclude, yes, very quickly.
We're going to lose our guest here in just a moment.
The second reason is that they wanted to exclude rebels and parties, so a rebellious group from the Spanish Civil War, they shouldn't be pirates neither. So this idea may be fit, for example, to kinds of situations of civil war, or environmental activists who are not pirates neither, because they have totally political ends. So in order not to become a pirate, the captain of a Shadow Fleet ship would stand up, I do it for my fatherland, or anything like that, to say that he has no private ends. But still the burden of proof is up to him that he's not a pirate. Thank you.
Thank you very much. I hope all of this is being recorded, by the way, because I think for those who are working on this file, on this brief, trying to come up with effective legal arguments, it's really worth hearing some of this fascinating background as well, historical background. But Stylianos, we heard also from Moritz how the ability to effectively combat piracy in this case, in both Asia, the examples given in both Asia and Africa, evolved out of a cooperation. You know, we're talking about global cooperation for standards and legal contexts here. And he said and we saw the graph on how that succeeded in effectively combating piracy in those two examples, how the numbers went down. And he was even involved in some of that himself. So I'm just wondering whether there is a consensus building among the member states that are represented in your Center of Excellence in Helsinki on the legal means that could be applied. Do you see a consensus building? Because, you know, we're talking about the legal underpinning of intervention, but then there's the actual enforcement part too, right? So first of all, do you see a consensus building among the member states on the legal context here? And do you see that being any means for that being translated into effective enforcement?
Thank you for the question. Actually, this is a very challenging matter. We have been studying this matter for almost 1.5 years. And the outcome, as you saw in my presentation, we found almost 5 different incidents with states, and each state followed with a question mark a different approach. For the time being, we can't see that there is a consensus of the legal approach, but we have a consensus that we have to stop the ship. This is not a matter of legal approach. What is matter is the outcome, that the ship have to be prevented and not continue to sail and cut cables. So, the good news is that states have tools in international law to exploit if they have adopted these international rules in their national legislation. This is a very critical and important issue. For example, Finland, as I mentioned, is not part of 1884 Convention, but Denmark is. Germany is part. USA is part, but USA is not part of UNCLOS. So it is a complicated issue. Of course, the debate between lawyers with expertise on international law, maritime law, is huge, but all they can agree that after all, the political will is what is matter. And this is the approach of hybrid center. We want to provide concrete solutions to participant states to facilitate them to protect themselves and their interests. This is my first approach, and thank you for your contribution to this. Of course, the piracy is a very important view of how you can address these hybrid threats. And of course, they are very effective. But then we have the problem of do we have the capabilities to enforce the law?
Yeah, quick remark.
Just to mention that after the English incident, Russia called Finland as pirates of the the Baltic Sea.
If I just may, because thank you very much. You were mentioning the 1884 convention, which has two shortcomings. First of all, there are just 36 signatories, and I think the last one acceded the treaty more than 100 years ago. So it's a pretty sleeping convention, and we have some major states being party to it, but the problem is most of the flag states are not. So we are dealing with ships flagged in Palau, Liberia, Panama, and so on, and most of them are not party. Well, these states mostly didn't exist at the time of 1884. So they are not party to the convention, first of all. And still, if we want to seize a ship or board a ship according under this 1884 convention, we need the consent of the flag state still. And this makes it difficult because if Liberia says, well, we don't want to, then, well, have a nice day at sea. That's all we can do. And that's why I find these piracy provisions so tempting, because these are the only provisions in international law of the sea, basically, where you can seize and board a ship without the state's consent. And then still, it's about capacity building, and there will be national discussions going on, who is responsible, will it be the Coast Guard, will it be the navies, but these are discussions which should be dealt with later. We had the same discussions with the piracy and the Horn of Africa too. Will it be GSG-9 or the Navy? And these discussions will be met, but I'm sure there will be a solution, and who has the capacities to deal with this nationally, according to national law. And I think I wouldn't bore you with the question who, according to my point of view, will be responsible, the police or the Navy. But as soon as we agree that we have the capacity and we have the rights to deal with these sabotage acts, then the second step will be to ask ourselves, how can we best do this? And then it's probably tempting to look at the lessons learned from other international operations like Atalanta or the RECAP ISC and Djibouti Code of Conduct situations.
It's great to hear, again, bits of optimism coming through here. The idea, yes, he's sure there will be solutions. I like that. I know you got to leave right now, and don't worry, Domas. We've not forgotten about you. My apologies for not getting a word out of you yet this whole time. But we're going to lose Stylianos right now. So last word. I know you got to leave in 2 minutes. Any idea you want to leave us with here, Stylianos, before you go?
First of all, thank you for having me here in order to discuss for this very crucial matter. I'm expecting the next year conference about this munition clearance wing, and just a proposal that, of course, I fully agree with you. There are solutions. The only thing that we have to do is to believe on this approach that there are solutions. And a legal proposal for for states, for a legal advisor of the states to delve in Article 25 of ARCIVA. Of course, this is a very technical issue, but keep in your mind Article 25 of ARCIVA. Maybe this is the solution in our problem. Thank you very much.
Stylianos Tzimis, thank you very much. A warm round of applause for him. He's going to have to leave us now. Thank you. Okay, I'm really sorry, Domas, that we've waited this long to bring you in, but you could tell that there were legal issues coming together on this particular topic, and I know that you're going to be focusing more on UXO, which is has been the principal focus of our conference, right? But we're now, again, we're dealing with two separate strands, one on critical infrastructure, one on UXO, and we look forward to hearing your presentation now, if you have one, on UXO, dealing with that aspect.
Hello, dear colleagues, friends. I am very grateful for the invitation, for being here, and I am going to bring UXO back to on the agenda, because primarily I am desk officer for UXO in DG MARE, and I am part of maritime security and surveillance team, and I hear from Wednesday. And I learned a lot about the UXO, about how you are dealing with this, about the expertise you are bringing here, and I'm so grateful that I spent here. As a professional, I am learned a lot, and I have to acknowledge that Germany is doing pretty well, and I adore what they do. And this 100 million program on UXO, it's out of scope. It's mind-boggling, and I think it could be called the European benchmark in terms of ambition, in terms of precision, and in terms of purpose. Because it could set the higher standards for other states, how we can deal and tackle UXO issue. So briefly, only want to take a look. I'm going to focus solely on Baltic Sea, and here you see an overview how it is contaminated and how it's affected by chemical and conventional UXO. So you are experts, you know about this very well. I don't need to bother you more, but yeah, this map indicates and highlights that it's a huge problem. Okay, let's put a little bit on the policy context, and we have here in broader scope Marine Strategy Framework Directive, and it's a very important piece of legislation which determines how we have to deal with environmental issues and how we have to seek the right balance between the health of environment and economic activities for fisheries, coastal activities. Another piece of legislation, EU missions, it seeks and aims to restore and preserve our oceans and seas and waters till 2030. And now we are going deeper into policy of UXO, and first, Commission decided to ascertain what is the real situation in this field, and we ordered the study, and the study revealed that the most contaminated sea in all European sea basins is Baltic Sea. Yeah, it has some conditions. It's very shallow waters. It's enclosed. There's no circulation, and urgent actions are needed. And then we revised, as you see in the middle, EU Maritime Security Strategy in 2023, and among other issues related to maritime security is UXO. And in that strategy, we put action plan, and this action plan, it's mapping UXO in all sea basins of Europe, starting from Baltic Sea, building capabilities for technologies, resources, and gaining more funding, and from technological development. The last is very important, is our Baltic Conference, second edition. And during this conference, ministers gathered from all Baltic Sea, and they made clear commitments that we need to strengthen cooperation with regional actors like CBSS and HELCOM. We need to bridge the knowledge and legal gaps. All of colleagues said and underlined that there is no information exchange, and that is the main problem. And yes, we need to prioritize high-risk areas for UXO elimination and explore funding mechanism. So now I'm going to elaborate a little bit on priorities, initiatives, and projects, and what comes next. So in order to understand how EU works and how we can fund UXO-related projects, we have three main financial instruments, and the first is European Maritime and Fisheries and Aquaculture Fund. It's relatively not so big, but we can fund this, and it's, by the way, it's being managed by DG MARE, where I am from, and we can fund initiatives related to blue economy, to fisheries, for coastal communities, and also we can fund projects that tackle UXO. The second one is a little bit bigger. It's Horizon Europe. Horizon Europe is everything that's related to research and innovation technologies. And the last is, not least, there are some others, but I am just underlining the main, European Regional Development Fund. And this is the nature of this fund, that we have to support regional cooperation to boost technologies and sustainable economy. And now we are going directly to these projects. So I don't want to put more emphasis on that, because yesterday distinguished colleagues presented very, very well with very nice moderator from CBSS. And these projects, I should mention that they stem from different nature. And for example, Minesweeper is from Horizon Europe. So it's purely for technological development, research and innovation. And is being, the lead coordinator is Geomar. I don't know, Jans is here, but I believe that they are doing a great job. The second one, Munimap. I see Jacek is here, and this comes from the Regional Development Fund. And as Jacek underlined, that they will provide recommendations how we can move with the regional remediation of this UXO. It's legal, it's a policy stuff, it's a legal gaps, and we trust you will deliver very good results, and we reap from these results and work further. MUNIRISK comes from MFAF fund, and as I said before, MFAF is for blue economy, fisheries and coastal communities, and they are going to prioritize the mostly affected areas. They are going to map 4 sites, and the recent project and initiative that was only this week has been signed a grant agreement. Unfortunately, I asked Jens from GMR, who is the lead coordinator of this. I don't have logo, but it's award. And this is camera that also should provide the large-scale technologies for large-scale remediation of UXO. And it should be scalable, it should be, the lessons learned should be transmitted to other regions as a Baltic Sea, or Black Sea, and North Sea. And I would call it like little German remediation program. It's more or less the same nature, but money is not the same. It's like 6 million, and it's by way funded by European Parliament, and it's a pilot project. And we hope that this project will be successful, and later on we can implement some programs, new programs, because of this. So it's a good step forward. And now it's a very recent initiative. I don't know whether you have heard about Ocean Pact, but it was last year revealed in UNO conference in Nice, and this I would call a game changer because it's a holistic approach. We have like 6 parts, 6 pillars. And one of these pillars is maritime security. And in this maritime security pillar is UXO. And it tasks us, Commission, to write a big coordinated UXO removal strategy. Yeah, what is the strategy about? It should be regional, it should have regional focus. So that means that we will start from Baltic Sea, and then to Black Sea. It should be technology-driven driven solutions, and it has have great cooperation with regional partners like HELCOM or CBSS. And yes, and it's, as I said before, it's a game changer. It's and it underlines that UXO is it's not like technical issue. It's very high on EU political agenda. It will be funded, and it will be strategic. And looking ahead, we believe that Baltic region is more than just a starting point. It's our pilot, it's our innovation hub, and a model for how to scale UXO remediation process. And the last, I want to outline what we as a Commission will do. We will keep this UXO high on the political agenda. We will support member states in delivering Palanga commitments. And we will build this strategy on the lessons learned from this project, EU funded. So someone from previous speakers said that it's not I or you, it's us. It's up to us if we put a lot of effort, if we make this breakthrough moment, it will stay high on the political agenda, and it will be created a good, comprehensive UXO remediation strategy. So let's work together, and let's keep UXO topic high on our daily agenda. That's all. Thank you.
Thank you very much. Excellent. No, I really appreciate you also bringing us back to where this conference started 4 years ago too, in dealing with UXO or UXO, and munition clearance, which is still in the title of the conference. I'm wondering if we're going to end up with a different title at some point when as the conference evolves. But thanks for bringing us back to that. And yeah, in some ways, I wish we had your presentation at the beginning of the conference, right? Because the need for what you're talking about there is exactly what we're addressing at this conference. The need, as you put it, for a coordinated, phased UXO removal strategy, right, within the European Union and within the among particularly the affected states who have the coastlines and the waterways that are in effect, that do have these unexploded ordnance, these munitions still there. So you mentioned that there's a political will, or that it's high on the EU political agenda to address this topic, that there will be money coming from this, that there will be lessons learned from these projects that you described and that are represented here in the room as well, and have been contributing to our discussions over the past 3 days. I'm just wondering when we will see this coming together. I mean, do you have a time horizon? Do you see this being translated into coordinated approaches to effectively address the 1.6 million tons of unexploded ordnance that's in just the North Sea and the Baltic Sea alone?
Yeah, I just want to underline that since 2016, Commission, European Union invested in UXO-related issues 24 million. So it's but it's like piloting, trying to understand the situation of the sea basins, and now the main step forward will be to take a stocks at the next Baltic Sea conference, where Baltic Sea state ministers will come and will evaluate and will take a look why and how these projects that I mentioned, what with lessons learned. And it will be a framework of further to draft this comprehensive UXO removal strategy. Yes, we are very closely following developments with German 100 million remediation program, and we also have some contacts with others like Japan, United States. This UXO is not in Baltic Sea; it's everywhere. But why Baltic? Because it's most contaminated. There's no circulation ways enclosed, and it's a very big need for offshore wind farms to build up. So, yeah. We are drafting, not how to say, we will reap all these benefits from these projects. We will from the lessons learned, and how we are going to move forward with this remediation strategy.
Thank you. We have about 10 minutes left. I'd like to open the floor to questions. I know that our crowd is thinned out a bit. That's normal for a conference of this kind that goes on for 3 days. To get into the last phase of it, it tends to thin out. People need to get back to their offices and places of work. But the microphone is there. Just please feel free to approach the microphone. There we go. We got our first question. Yes, sir.
Hi. My name is Sanne van Benne-Beckman from TNO, the Netherlands. I have a question about the legal debate that we had. So you're focusing mostly on when an accident already or an incident happened and what can be done afterwards. And I'm just wondering, so we see a lot of monitoring of infrastructure by Russian vessels. And I'm wondering, is there any what's the legal space basically to act on that?
On the monitoring of Russia monitoring critical infrastructure, is that right? Yeah, okay.
No? Yes. Well, there's some legal space. I mean, first of all, around infrastructure you can have a safety zone of 500 meters. That's not much, especially when we're now dealing with high tech who can observe certain infrastructure objects from very far away. And obviously, well, we could call sea cables infrastructure first of all, but if you have a 500 meters strip through the Baltic Sea, then there won't be any navigation left. So this is obviously, you can have, for example, if you have cables between within a wind farm, you can declare a security safety zone around this wind farm, which also protects the cables within, but obviously not those cables who transgress it. So, well, so it's hard to stop ships from just going there. I think it will be up to monitoring really. You need to have the capacities. You need to have ships. Yesterday I read in the newspaper that Denmark is starting with these sailing drones to observe the sea. Then you can put up a system which does electronic detection. For example, I briefly mentioned this danger by spoofing and jamming, which also comes from ships from the Shadow Fleet against infrastructure and also against ships. With a detection framework, which I'm sure the different navies have already installed, but I think there might be some difficulty with sharing the information. So this would be a first step, sharing the information you have. And then obviously you can put cameras on it, on these certain infrastructure elements to monitor them, to protect them, and you have satellite surveillance too, and you have the option to monitor telecommunications coming on. So these are the options to monitor, and then to have your ships or your naval and coast guard vessels within the Baltic Sea, and then to engage with dangers to these units of infrastructure. This would probably be the way to go ahead. And this needs some international cooperation, obviously, and that's why I proposed to look at the lessons learned, to look at the best practice reports from RECAP and Djibouti Code of Conduct, for example, as a first start, to see how we can enhance cooperation with regard to that. Does this answer the question?
Thank you so much, Moritz. We've got one more question coming from Jacek. I know that, but hold on just a second, because Domas wants to comment on this as well.
Yes, I also, talking about the laws, how it will be done, exceptions, cases, but I want to remind that European Union has a very great initiative platform. It is CISA. It's Common Information Sharing Environment, and it's about the cross-sectoral, cross-border, and it involves the Navy, the customs, ports, and the main thing that now we are struggling with information sharing. And this is platform, this is, by the way, started operational, and in other sea basins it's working very good for search and rescue operations in Mediterranean, and the Baltic Sea is not fully covered, but Finns, Sweden and Germany is synchronization with technologies, because they're still not ready operational, but it's a good instrument in order to monitor and in order to send information. Like there is if you see, for example, jamming and spoofing, abnormal behavior, you sending this information to all of your partners, and you seeing that we drag this anchor. So you have to be prepared for that, and if you are prepared, so it's good.
Thank you. Jacek.
Hey, this is probably very, very naive question, but I haven't seen like a one option between these different legal options regarding the shadow fleet actions, and the question is related to the flags of convenience. It's like, would it be possible for a country to just straight declare war on Panama or Barbuda or something like this and seize the ship and then keep it until the peace treaty is signed?
Well, that's not a stupid question at all. And first of all, there are the obligations on the law of the sea. Let's just left it out. There are sea cable provisions also, which actually require those states of convenience to make sabotage acts a crime under their domestic laws and to punish it accordingly. But, well, those states don't. So we could sue them at the International Tribunal for the Law of the Sea in Hamburg for failing. We also might, and that's an interesting thing, which my co-speaker mentioned earlier, to refer to the draft articles on state responsibility, to have some countermeasures because an erga omnes provision of the law of the sea has been violated by these. But I haven't thought about this. I have to think more. That's just something which propped up to my mind. Well, a ship is no extraterritorial unit. This is different than many people think. So if you go now have a visit, I think the American ships entered the harbor in Kiel, and if you have the invitation to the ship, you won't enter American soil within the sea, within the Kiel harbor. Unfortunately, maybe, because I heard it's pretty tough to get to America in other different ways now. If a ship is attacked, this is no attack, or if a ship is attacked, this is no attack on the state itself, and that's not even an attack by the state. So you can sue the state at international courts. You can even enact some countermeasures according to the draft articles on state responsibility, but you cannot go to war against these states if they just damage infrastructure or do some spoofing and jamming. And then it's up to the scholars and the professionals to say when is the threshold met, and there it is, well, 3 lawyers, 5 different opinions. When the threshold is met, that actually an armed attack has occurred, which activates the right to self-defense, but within these acts, definitely not.
Thank you. We have just about 3 minutes left, and there's Jan. I know he was going to say some final words, but I would just ask both of our speakers who are still with us if there's a final thought you'd like to share, and if there's not a specific final thought, then my question to you would be to get a final response from you. What would you say is the one thing that needs to happen within the next year to improve the sense of cooperation to address the problems that we're talking about regarding critical infrastructure, protection of critical infrastructure, and also remediation with unexploded ordnance? Start with you, Panel.
Just regarding the infrastructure, when these cables were cut, EU took very clear actions. We prepared the communication of safety of cables, and in addition to this, we released this Protect EU internal defensive agenda, and in terms of Baltic Sea countries, they prepared memorandum for better, closer cooperation, and as far as I know, now we are creating the group for on technical level how to communicate and how to build on this knowledge. And regarding the UXO, it's still. But UXO, it's not, it's now, I think we are on the move, everything is okay, political will is here, knowledge is here, expertise is here, and I think that we just want to take actions.
Moritz, final words?
Yeah, thank you. I might finish with some personal experience because I just come back from Gdańsk, being 50 kilometers far away from the Russian border. And last week I engaged in discussions with students over there from Estonia, from Latvia, from Poland, and I was often overheard people saying, "last summer in peace." And this made the whole situation very vivid for me. And we sit here in Kiel and pretty relaxed and we enjoy our summer, and we should do. But people who live that close to the border, to the Russian border, they don't feel that relaxed anymore. And I think they can't be calmed by Secret Service assessments saying, well, the Russians might still need some time to get mobilized and that's so on. So I think we definitely should get started, and according to my point of view, Russia understands the language of strength and not the language of reluctance. So in order to prevent an escalation, we should show strength and show activity instead of hiding behind the fence of international law, which, well, isn't actually a fence. Thank you.
Thank you very much. As we heard from Dirk Peters earlier, I mean, we heard it from the European Commission in this case, someone saying that we're not, it's not peacetime anymore. We're in a state of pre-war, which is a really very sobering statement, I found. In any case, we're going to wrap it up here, but we have some final remarks coming from Jan Wendt, the driving force behind this whole conference. But first, a warm round of applause for our speakers on this final panel, and one word of appreciation from me. Thank you very much.